The latest news, national issues, the political scene, and conversations with prominent personalities. All these firsthand at the forefront. Good morning. I am Attorney Karen Jimeno. The 2025 national elections is months away, but the Commission on Elections, led by Chairperson George Garcia, has a lot on their plate. Following the official filing of COCs, the COMELEC is now screening the candidates to filter out the unqualified ones. The Commission is also busy testing the vote counting machines and the overall automated election system by a new provider, Miru Systems. Controversies notwithstanding, Chairperson Garcia and the COMELEC must work on ensuring not just a clean and honest 2025 elections, but also a peaceful and orderly one. Is the COMELEC chair ready to face the challenges of the 2025 elections? Joining us this morning is Commission on Elections Chairman George Garcia. Good morning, Chairman George.
Good morning, Attorney Karen. Good morning to all the televiewers.
Let's start with those who have filed the certificates of candidacies. So for Senate alone, there were about 184 that filed COCs. That's a huge number. Are we really going to see those names in the ballot?
Well, actually, Attorney Karen, in the entire country, 44,000 more or less aspirants filed their certificates of candidacy from senators down to the last councilor. Indeed, you are correct, 184 filed their certificates of candidacy as candidates for senators, but one withdrew before even the last day of the filing of the certificates of candidacy. So as stands now, we have 183 aspirants for the Senate, but we are now going to reduce that. Hopefully by tomorrow, we're going to deliberate on the recommendation of our law department saying that out of the 183, they came up with a list of about 66 aspirants who might land to be listed in the ballots. And how about the remainder of the 183? We're going to deliberate as to whether we're going to give them due process for purposes of asking them why they should not be declared nuisance candidates. For the party list, Ma'am Karen, Attorney Karen, we actually was able to receive 190 certificates of nomination and acceptance, but out of the 190 actually, it should only be 160. There were about 30 party list organizations and political parties who filed their certificates of nominations and acceptance, even if they are not actually candidates or they are not accredited by the Commission on Election. So of the 160, 4 did not file their certificates of nomination and acceptance. So we will include only 156 party list organizations and political parties in the ballots.
And for party list system, this has been the subject of abuse. A lot of political families, even business groups, use this to enter politics. How does the COMELEC screen party list candidates?
Indeed, Attorney Karen, under the Constitution, under Article 6, Section 5, it says that the party list system must represent at least 20% of the total membership of the House of Representatives. And in accordance with the mandate of the Constitution, Republic Act 7941, or the so-called party list law, was passed sometime in 1998. Take note, since 1998, it had not been changed. There was not even a single amendment of any provision of Republic Act 7941. Hence, in several instances, the Supreme Court had to interpret a lot of provisions of Republic Act 7941. To a certain extent, indeed, it's sometimes we can call that abuse. It's being abused by certain elements, certain politicians, certain groups, because it would appear that they are no longer representing the marginalized or underrepresented sectors. But however, there was this decision of the Supreme Court which said that you need not be wallowing in poverty to be representing a marginalized sector or a particular underrepresented sector. What is important, according to the Supreme Court, is that you must have a proven advocacy as regards this particular sector. So that is, I think, that is the gray area now. When you have that proven advocacy in that particular sector. You may be a billionaire, but if you have advocacy for the farmers, for the fisher folks, for women, youth, then you can represent. Meaning to say, if you want to represent the women's group, you are a man, then you can represent them. If you're a woman, you want to represent the men's group, then it's okay, because so long as you are able to prove that you have a proven advocacy for that particular sector.
And who checks that advocacy? Is it COMELEC? Do you look at the track record of the person, if they're really connected to that advocacy?
Yes, Attorney Karen. Immediately after the filing of the certificates of nomination and acceptance, here comes now the COMELEC screening the nominees. But however, we would appreciate very much if somebody, a registered voter, will be filing a petition either to cancel the accreditation of the political party or party list organization, or to question the qualification of a nominee. That's very important, simply because the COMELEC cannot by itself motu proprio cancel the certificates of nomination of somebody, except if that person is a nuisance candidate. That's provided for under the law. So here comes now the voters. We are asking you, if we are pleading with you, if you can please file petitions against them. And that's the reason why we are going to announce and we're going to publish the list of candidates, the certificates of candidacies of all candidates, the 44,000, in our website. Just wait for it in the next 2 weeks. And at the same time, we're going to publish the names of the nominees so that everybody will have an idea who are the nominees of these particular candidates.
And what are the common grounds for disqualifying candidates or nominees of party lists?
Well, when it comes to candidates, we can disqualify or cancel the certificates of candidacies of a candidate simply because that candidate is a nuisance candidate. Under Section 69 of the Omnibus Election Code, a nuisance candidate is a candidate who would cause confusion among the electorates because of the similarity of the names. They do not have the real intention to run for public office, or they wanted to create a mockery of the electoral process. That's the definition, and we have several cases already involving nuisance candidates. Now, we can likewise cancel the candidacy of somebody because we recently passed a resolution which says that those who were dismissed from the service and who has this perpetual disqualification to hold public office will not be allowed to file their candidacies, meaning we accepted their candidacies, but we are going to remove them from the list because we will implement the decision of the Office of the Ombudsman. We are saying that we are respecting the decision of the Ombudsman, and under Republic Act 6770, the Ombudsman Act, the decision of the Ombudsman is immediately executory in administrative cases unless restrained by the Court of Appeal. So we will implement that. Now, the third one is, it pertains to a registered voter who wanted to question the eligibility of a candidate, meaning based on age, citizenship, residency, registration as a voter, and literacy. So somebody must be able to file a petition to deny due course or cancel candidacy. And take note, Attorney Karen, it's not a question of qualification, it's a question of misrepresentation. We will disqualify, or we are going to cancel the candidacy simply because this candidate lied
in their certificates of candidacy. So kung may inaccurate statements sila doon.
Yes, Attorney Karen. And of course, the last ground for us to be able to disqualify a candidate is one who violated election law, such as vote buying, such as illegal campaign materials. So we can disqualify them. But then again, somebody must be able to file a petition to disqualify. And then therefore, overall, it is very, very clear that the only way by which the COMELEC can motu proprio cancel the certificates of candidacy of a candidate is if the candidate is a nuisance candidate. But in accordance with the decision of the Supreme Court most recently in the case of Cipriano versus the COMELEC, the Supreme Court said, still, even if the person might appear to be a nuisance candidate, due process must be afforded to him, and therefore he will be given a chance to answer and explain why he should not be declared a nuisance candidate, and it will be referred to a division of the COMELEC before it will go to the end bank of the Commission.
Okay, so COMELEC will be really busy hearing disqualification cases and then evaluating the candidates. Chairperson George, Pastor Apollo Kibuloy was indicted in the United States for criminal offenses. Is he qualified to run because he filed a certificate of candidacy to run for Senate in the Philippines?
That's a very good question. Well, first, they are saying, some of the groups are saying that we should disqualify Pastor Apollo Kibuloy as a nuisance candidate simply because of the certificates of nomination and acceptance attached to his certificate of candidacy, which according to a group in the party does not belong to them. It's actually a misrepresentation according to that group claiming to be the owner of the political party. It appears to be that when we verified with the records of the commission, there were actually two who filed their authorized signatories. And one of the authorized signatories actually is the one who signed the certificate of nomination and acceptance of Pastor Apollo Kibuloy. So here comes now the case involving whether he should be declared a nuisance or not. Now here comes the second case because of indictment in the United States. We have to understand that under Section 68 of the Omnibus Election Code, before a person can be disqualified, he must first be, there must be a final judgment of conviction, meaning a conviction by itself does not disqualify a candidate. And that's the reason why in the case of Halusos versus Comelec, the petitioner there was allowed to run because although there was already a decision by the lower court, this case is still on appeal. And that's also the reason why we are allowing even our persons deprived of liberties, though they are still waiting for the final judgment in their cases, are allowed to vote on election day. So long as there is no final judgment of conviction, then the person can be allowed to vote. And therefore, I had not directly answered the question as to whether he should be allowed to run or not. But I'm simply saying these are the facts and these are the law applicable.
Yeah. And so, as of now, Pastor Apollo Kibuloy is not disqualified to run for Senate.
He is an aspirant. He filed his certificate of candidacy. And let's see if his name will be included in the magic list that the Comelec will come up for purposes of determining whose names will be printed in the official ballots.
Okay, and in that case, is Alice Guo also still qualified to run for mayor?
Alice Guo did not file her certificate of candidacy. At that time, we were saying we will accept the certificates of candidacy of anybody in accordance with the decision of the Supreme Court in the case of Serafica versus the Commission election. The Supreme Court clarified that the duty of the Comelec is merely to accept the certificate of candidacy. It's a ministerial duty. We have no option, we have no discretion to refuse acceptance of the certificates of candidacy of anybody. But despite the ruling, it doesn't mean that once the Comelec accepted your COC, your name will be automatically included in the list and therefore will be included likewise in the ballots. It's a different question altogether. Now, in the case of the personality that you mentioned, I honestly believe that there was this decision of the Office of the Ombudsman which dismissed her from the service, and there is this disqualification to hold public office
as part
of the judgment of the decision of the Office of the Ombudsman. So, using that as basis alone, and using as basis the resolution that was issued by the Comelec and promulgated, then it would appear that any person with such kind of judgment from the Office of the Ombudsman, the candidacy will be definitely cancelled. So that's the point and that's the reality. About any other case, like for example on the case involving citizenship or whatever, when she filed the certificate of candidacy in October of 2021, nobody questioned, nobody petitioned, nobody opposed the filing of the COC, and therefore she was able to run, she was voted, and she was proclaimed because somebody must be filing a petition against her, not the Comelec, but a registered voter. We do not know the entire, the total number of the candidates in the entire country, so a registered voter must be able to do that. In this particular case, although nobody filed a case against her for disqualification, the administrative side, we found out that she may be held liable for the criminal side, which is misrepresentation. You know, a candidate who misrepresented herself or himself in the COC, not only materially, but a simple misrepresentation can be charged with misrepresentation under Section 261 of the Omnibus Election Code and can be charged with perjury under the revised penal code.
So let's take a step back, Chairperson George. For Alice Guo, for the record right now, is she running for mayor?
We did not receive any certificate of candidacy. It was announced in the Senate hearing during the time of the filing of the COC that she will not be filing for any position for the 2025 elections.
Okay, so she's not running. I mean, she hasn't filed any COC and that deadline has already lapsed.
Yes, Attorney Karen, but we came up likewise on October I think October 7, October 8, with a resolution formally charging her with an offense of misrepresentation under the Omnibus Election Code based on what the filing of the candidacy in 2021. It's our determination based on the findings of our experts that the fingerprints in 6 documents were actually one and of the same person. And one of these documents actually pertains to the fingerprint of one Gua Waping. And therefore, the other 5 fingerprints, which actually match with that particular fingerprint, belongs to one and the same person.
Okay, so that's in relation to what she filed in 2021, and there seems to be misrepresentation there.
That's right.
In terms of her citizenship.
That's our findings, Atty. Karen.
And what are the rules for premature campaigning? So a lot of candidates right now have posters up, but some of them, of course, are not explicitly saying that they're running for a specific position. Some are active in social media. How do you know if a candidate is engaged in premature campaigning?
Thank you very much, Atty. Karen, for that question. For our televiewers, for our countrymen, we have to understand that in the decision of the Supreme Court, in the case of Rosalinda Peñera versus the Commission on Election, the Supreme Court clearly emphasized that a person who filed his candidacy in an automated election, which will be by 2025, under Republic Act 9369, which is the automation law, they are not yet candidates at the time of the filing of the candidacy. That's according to the Supreme Court, citing Section 15 of Republic Act 9369. And therefore, what is the implication of that? The implication is, number one, there is no more premature campaigning for candidates running in an automated election year, which is 2025. Number two, they will be candidates only at the start of the campaign period, which is February 11 in the case of national candidates, senators, and party lists, and March 28 in the case of local candidates, meaning 90 days before the election for national positions and 45 days before the election for local position. They will only be candidates beginning that time or that period. And so all of their tarpaulins now that we can see in the streets, all of their advertisements, perhaps on television, radio, and newspapers, even in social media, they are not prohibited simply because they are not yet candidates. They will be candidates only at the start of the campaign period. And likewise, all their expenses from October, November, December, January, and even February up to the second week of February are not to be included in the SOSE because they are not yet candidates. We would like to explain that simply because we do not want the COMELEC to appear to be inutile in the minds and the eyes of our people because we cannot prevent them. But the truth is we really cannot prevent them because they are not yet candidates. However, in the case of the barangay and SK elections, we impose the regulation that they are candidates upon the date of the filing of the candidacies. Why? Because barangay and SK elections are manual elections, and therefore, it's not automated, not covered by Republic Act 9369.
But all of this sounds like a technicality. Do you think, Chairman George, honestly, that this is fair?
I personally, I think it's unfair. I think it violates the Equal Protection Clause of the Constitution. But the COMELEC cannot do anything, Atty. Karen, because we only, under Article 9C of the Constitution, is the institution to implement and enforce election law. We do not have the power to even amend the law, and we do not have the power to even defy the Honorable Supreme Court in its pronouncement. Even the Supreme Court, through Mr. Justice Carpio, in that case of Peñera versus COMELEC, said that they cannot do anything because that is what the law provides. And therefore, until the law is amended or changed, then that will have to stand, and that will have to be implemented by the Commission.
Well,
hopefully, somebody will go to the Supreme Court again and question our regulation, which we base on the decision of the Supreme Court.
Yes, and you know the irony there. The law can only be amended by the people who are congressmen or senators. So that would be to their disadvantage if they perhaps change the rule.
And Atty. Karen, that's the reason why, as a compromise, because I would like to stand firm that they should be candidates at the time of the filing of the candidacies, but as a compromise, we said that there will be no more substitution. Once the last day of the filing of the candidacy had expired, and therefore only up to October 8 can there be substitution. Meaning, if you file your candidacy, except if you will die or you are disqualified, then you will not be, if you withdraw your candidacy, you will not be substituted.
Okay, so that's a new rule now that was issued by COMELEC. There can be no substitution of candidates after October 8th.
That is right, no more substitution. And that is true not only for national and local candidates, but also for the party list. They were required this time to submit 10
All their
nominees.
nominees.
Before, they were required only to submit 5 nominees. This time, 10 nominees. And in the event that all the 10 nominees will resign, will withdraw already, then we will no longer accept any substitution of the 10 candidates, because it happened before in the past. We require them to submit 5 nominees, and then all of a sudden, after the election, all of the 5 nominees will withdraw, because all of them became sick. And so we will accept new set of nominees. And here comes now the nominee that had been known before as a farmer, fisher folk, or whatever, a super rich individual becoming now the congressman of this party list. Therefore, we would like to prevent that.
Before, they would field real people from that certain advocacy.
That's right.
And then last minute, we withdraw lahat and then magpapalit someone
After
who's
the election,
super
Attorney
wealthy
Karen,
and not part of that advocacy.
Yes, Attorney Karen. After the election, they will withdraw en masse. Lahat may sakit. And then, tapos biglang magsasubmit ng isang set muli ng nominees. This time, hindi na farmers. This time, hindi na teachers. Hindi na yung sector na nire-represent nila. So we found it so amusing, but at the same time, so irritating that they are trying to set aside what the law provides. And so
they're really gaming the system. And right now, with that 10 nominees, they are all capable of sitting as a representative of that party list,
yes,
if no one withdraws.
Supposedly, Attorney Karen, but of course, anybody can still again question any of the 10 nominees of the party list if they think, or a registered voter will think, that this person should not represent this marginalized and underrepresented sector.
And Chairman George, you've been an election lawyer for so many years before becoming COMELEC chair. In your personal opinion, do you think that the party list system is outdated, has been subject of abuse, and should be revised?
Definitely outdated, to a certain extent prostituted, to a certain extent highly abused, because as the time passed by, we should likewise modify, amend our laws, especially if there are a lot of loopholes. Come to think of it, the Supreme Court in one case originally had said you need not fill up the entire seats for the party list. And then several years after, the Supreme Court said, after enhancing the decision, the Supreme Court said, well, you have to fill up the entire seats for the party list. Here comes a decision, the Supreme Court said, you need not be a resident even of Forbes Park or even Dasmariñas Village to be a nominee. And then several years after, a new decision came up, and here the Supreme Court said you need not be wallowing in poverty to be able to represent. So meaning to say,
Chairman George, because of all these abuses that has happened with the party list system, do you think that the party list system should get ridden off? But before you answer that question, we'll have to take a short break. At the Forefront, we'll be right back. Welcome back at the Forefront. Chairman George, because of all the abuses that have been committed in relation to the party list system, do you think that the party list system should be abolished?
Attorney Karen, with all due respect, I don't think the party list system should be abolished. In the first place, it's provided for by the Constitution. It will require an amendment of the Constitution to abolish the party list system. Number two, it's a very good system. Actually, there are only some people who actually abused it and used it for their own personal, for their own personal interest. But we have to understand, right now in Congress, most of the bills that had been passed and authored and sponsored were actually coming from the party list. And at the same time, they're always active in committee hearings. They were the ones who always spearhead the committee hearings and asking relevant and very important questions during interpellations, and likewise providing for very good privileged speeches and very clear participation. So, siguro po, may ilan lang na umaabuso, but I don't think it should be abolished. This is part of our political system. And indeed, this is the opportunity for the marginalized and underrepresented to have a voice in our Congress. If only some had abused it, but it should not punish the entirety of the
So
sectors.
at least the legitimate party lists have been doing their job
And
for
that's-
the legitimate
And
ones.
that's the reason why, Atty. Karen, for the first time, after several years since the time that we have this party list system, we accredited only the present leadership 42 party list organization sectors. That's the lowest in the history of party list election. And so 42 only, and you have to add that to the existing 118. That's why we came up with 160 party list, still the lowest in the history of party list election.
Okay, so it's good that we're trying to filter out yung mga nag-a-abuse ng party list. But let's go to the elections. And recently, St. Timothy Construction announced that they were withdrawing from that group that won the election system bid. Does this pose challenges or legitimate concerns as to Miru Systems still being qualified to run the 2025 elections?
We made a proactive stand, the Commission and Bank. We learned several days before the last day of the filing of the candidacy that perhaps one of the owners or even an officer of St. Timothy might run for a local or even a national position. And we called the other remaining joint venture partners, the entire N-Bank. We told them that we are going to give them only two hard choices, either politics or business, meaning either they withdraw from the joint venture, or if they will proceed without withdrawing, we are going to disqualify the candidate for conflict of interest. And the next day, after the instruction was conveyed, the next day St. Timothy officially withdrew from the joint venture partners. And so because of the withdrawal, we have to understand what is the participation of St. Timothy. The participation was only for the financial aspect. Yeah. The net financial contracting capacity was provided for by St. Timothy. Wala po sila sa technical, financial.
But because they're gone, aren't they now, isn't there the remaining group lacking that financial capacity?
Last Friday, the remaining group, based on our resolution, submitted to us the new NFCC, corresponding to the NFCC actually, which was submitted before by St. Timothy. So it would appear really that the two remaining partners are able and capable to provide to us the NFCC. Yun naman pong NFCC is just a mere guarantee that in the event that the COMELEC will not be able to pay yet the company or any of the contractors of the COMELEC, that they will be able to still supply all the commitments to the Commission election. We have to understand right now, we have almost 67,000 machines in our possession out of the 110,000, meaning they were able to deliver already about 57% of their commitment. And as far as the printing machines to be used for the printing of the ballots, the NPO, because it's bundled, it's already delivered. It was delivered already in the National Printing Office, and it will be received officially by COMELEC by October 25. And so the other peripherals of the components of the contract were already 100% delivered. It's already in our COMELEC warehouse at Binyan, Lagunas. It was shown to the media and members of the Citizens' Arm. So meaning to say only a little portion of their contractual obligations are left. And at the same time, again, they were able to provide the NFCC last Friday. In fact, we're going to show to the public and to the media today the submitted NFCC.
And Congressman George, Congressman Erice, Chairman George, was here as our guest last week. And he had this to say about his concerns with Miru Systems.
Yeah,
we'll play you a video po.
Congressman Egay, what can be done at this point if the contract with Miru Systems is voided?
Well, I think the first things first, dapat siguro mag-resign si Chairman Garcia kasi ang priority niya i-cover up yung mga pagkukulang at pagkakamali nila, hindi kung paano aayusin yung elections natin. Kung merong mamamahala dyan na talagang tututukan, kayang-kaya pa na gumawa ng paraan para makakuha ng bagong provider.
Chairman George, what is your comment on
Well,
that?
the COMELEC is not only a constitutional body, but a collegial body at that. The decision does not only will be coming from me. It's a collegial decision. And therefore, we always rule by a majority in accordance with our rules. And therefore, whatever is the decision of the majority, even if, for example, the chairman, does not agree with the majority, I will have to implement and enforce as the head administrative officer of the commission. And when it comes to the resignation, I have no permanent wish for this particular office. In fact, this is a sacrifice on my part. I've been in election practice for 23 years, but then I really wanted just to contribute something in governance. And when it comes to resignation, don't worry about that. If a person is no longer needed, then anybody or I myself will be resigning from my office. Now, when it comes to our contract with Miru system, we have to understand that former Congressman Erice already filed a petition before the Supreme Court. And in the Supreme Court, he questioned the legality of the COMELEC entering into a contract with Miru system. That's the reason why the lawyer in me is actually saying, in almost all of the fora and interviews, I had been saying I will decline to comment on the merits of the case, because what he actually is discussing, or he was discussing in several of the fora, were the ones raised before the Supreme Court, and therefore the sub judice principle will always come in.
And that Supreme Court case relates to
the validity of the contract entered by the COMELEC with Miru. And fortunately for the Commission, and we'd like to thank the Honorable Supreme Court for that, the Supreme Court did not deem it necessary to issue a restraining order, and therefore that's the reason why we are continuing with the preparation. Actually, you asked him the question what will happen in the case the contract
with Miru system is voided.
Yeah. I answered that question before, and when I answered that question, a petition to cite me in contempt filed by him was filed before the Honorable Supreme Court because I answered that particular question. In my explanation to the Honorable Supreme Court, I told the Supreme Court, I'm the chairman of the COMELEC. I'm supposed to give the people the information, what will happen just in case something will happen like that. I was accused of threatening the Supreme Court, sowing fear to the Supreme Court. But what will really happen in case the contract is voided? But we have a plan A, plan B, plan C, and therefore I will not really answer directly in order not for the person to again file a petition to cite me in contempt before the Supreme Court.
Well, Chairman George, in relation to you speaking about the elections and the elections provider, Miru Systems, Congressman Egay also had this to say.
Nananawagan din ako kay Chairman Garcia, hanggang nandiyan ka, magugulo itong eleksyon kasi he is no longer the chairman He is now the spokesperson and the spokesperson of Miru, di ba? Hindi natin nakikita sino ba talaga yung CEO ng Miru joint venture. Sino ba yung mga nagpapaliwanag, ano ba yung mga problema? Wala. Si Chairman Garcia lang lahat So parang lumalabas siya na yung siya na yung CEO ng ng Miru joint venture.
Well, Chairman George,
swerte yung lahat ng mga providers namin dahil ako nagpapaliwanag. Buti nga nagsasalita ang chairman ng komisyon. Meaning to say, I am ready and willing to defend all the contracts that the COMELEC had entered into, because the people we will need to know everything. That is the principle that we adopted in the Commission under the present leadership. Number one is transparency. Number two is accountability. And number three is inclusiveness. That's why I was so open to everyone. I had been showing not only to the citizens, not only to the media, but to the public as well, all the processes of the Commission. First time, we have shown the data centers of the Commission. Before, you cannot even know where the data centers are or of the Commissions, because it's a highly sensitive location, but we have been showing that to the people. So meaning to say, I had been talking and explaining because that is my role. We have to communicate to the people. Kung napansin niyo, Ma'am Karen, all my explanations are in languages or in dialect clearly known to everyone, so that everyone will be able to find out ano ba talagang ginagawa ng commission. Hindi yung before na lagi na lang may secrecy o sinasabi parang lihim. So if I'm talking, in fact, I was accused by him not only as being the #1 salesman, I was even accused by him as the #1 seller of Miru system. But maybe we can ask him also, what is his desire really? And in several instances he said, we have to go back to the old machines. We have to go back, we have to use the old machine. Why are we going to use the old machines? These are antiquated machines used for several times, and in the last 2022 election, most of these machines malfunctioned. And in the barangay and SK elections, when we pilot tested some of the machines in Dasmariñas, Cavite, we have 3 contingency machines per precinct. We were able to utilize the contingency machines, meaning, paano pong gagawin namin kung luma na? We were given by Congress, the executive and the legislative, the budget to procure new machines. And in fact, we did not buy these machines. We merely leased the machines.
But the issue that Congressman Egay also raised was that for just leasing the machines, he said that we're paying too much. As Filipino people, he said that we're paying 18 billion pesos when we can use only 8 billion pesos for that type of leasing arrangement.
With all due respect, Attorney Karen, that is misrepresentation. The 17.88 is a bundled contract, meaning to say the amount for the lease of the machine was actually only about 15 billion pesos. And if you are going to divide 15 billion with 110,000 machines, that's only about 149,000 pesos. In 2022, the COMELEC at that time, I was not yet present before the procurement at that time. In 2022, the COMELEC asked Congress for 23 billion peso budget, which will amount to about 155,000 pesos per machine. Now, it's 149,000, it's leased, and we're not going to purchase the machines. The other components of the 17.88 actually are, number 1, printing of the ballots. Number 2, the laptops to be used for purposes of the consolidation of the results. Number 3, the setting up of the repair hubs. Number 4, the other peripherals that will be supplied to us by Miru system. And next, the technicians to be used in all the polling places. Meaning to say, so it's a misrepresentation. That does not constitute the machines alone. The machines are only for 15 billion more or less.
Have you been able to talk to Congressman Erice to fully explain? Because he said that he is willing to apologize kung mali siya. Let's watch this clip.
And prior to this, did you have any interactions with Chairman George of COMELEC?
Wala.
Ako nga, so
ang sabi ko nga sa kanya, i-present niya sa harap ko yung makina. I-justify niya, pagka mali ako sa mga allegation ko, luluhod ako at hihingi ako ng patawad sa kanya.
So, have you had an opportunity to talk to Congressman Erice?
I had no opportunity, just like what he mentioned. And it's not for me to explain the machine to him. He is not the Filipino people. I will explain everything. We explained everything in the Senate when we went to the Senate. In fact, the machines were, that we brought the machine to the Senate. It was Senator Coco Pimentel, Senator Amy Marcos, who viewed the machines, more particularly Senator Amy Marcos. And she said it's a very good enhancement of our the machine that we used in 2010 up to 2022. So, pinakita po namin. In fact, yung lahat ng issues niya, sinagot namin during the Senate hearing. And we honestly believe that the members of the Senate were so satisfied. The House of Representatives will be showing the machine this coming November also because of the request of the House. So, there's nothing secret about that. It's just a matter of the commission kasi, Attorney Karen, had prepared for the customization of the machine. Hindi lang po kasi yan delivery ng machine. There is customization, meaning the Information Technology Department of COMELEC prepared what the machine, how the machine will function, what the machine should, how the machine will read, because that's the role of the COMELEC. For example, hindi naman alam ni machine kung ilan yung kandidato sa buong Pilipinas. Hindi naman alam ni machine kung paano bibilangan yung boto ng bawat botante. So, i-customize pa yon. And so, when the machines are delivered, there will be a hardware acceptance test, and after that, there will be customization. We are finished already with customization, with the hardware acceptance test of the machines already delivered. That's why we are prepared by November to to bring the machines to all the parts of the country in the entire municipalities and cities. So
we will be able to see it.
we are going to
demonstrate niyo po.
We are going to demonstrate the machine here in Billionario. And ang sasabihin na naman sa akin, ba't daw ako nagde-demo ng machine?
Well, that's your job.
Atty. Karen, di ba masaya nga na dapat ang chairman mismo ng COMELEC ang nagde-demo ng machine sa mga estudyante. In 36 times that we went around the country para sa mga universities, sa mga public institution, private institution, ang chairman ng COMELEC ang nagde-demo ng machine. And take note, walang foreigner kahit kailan ang nag-demo ng machine. Because only ITD people, yung PKO namin, ang na-train na mag-demo ng machine. That's a very good relief. Before, Atty. Karen, ang nagde-demo ng machine, di ba? May mga foreigners before. Ngayon, that cannot happen. This election is the election of the people of the Philippines. This is a Filipino election, and therefore, only Filipinos should be the one handling this election.
And former Senate President Tito Soto mentioned before that we could also consider hybrid elections. What are your thoughts on that? But before you answer that question, Chairman George, we'll have to take a short break. At the forefront, we'll be right back. Welcome back at the forefront. Chairman George, former Senate President Tito Soto suggested a hybrid election system. What are your thoughts on that?
Atty. Karen, I, for one, was actually before when I was a practitioner in favor of the hybrid system of election. But however, we have to understand that there is a need for a law that will authorize the COMELEC to venture into a hybrid system. The present automation law, Republic Act 9369, pertains to a full automation of the election. If you are going to hybridize it, then there is a need either to amend the law or to pass a new law for a hybrid election. And so at this point, we cannot do that in the absence of the law. Number two, we already pilot tested hybrid election, meaning you're going to read the ballots. After reading the ballots, you're going to insert it in the machine so that the machine will be able to count. Based on our initial estimate, it will take at least 3 days. So that the entire ballots of the voters who cast their votes on election day will be counted. Simply because, you see, Atty. Karen, if there are about 70 candidates for senators, and you are to elect 12 senators only, the teacher who will be reading the ballots will have to count first how many senators or aspirants were elected by the voter. Because if the number of votes cast is actually more than 12, then you are not going to read, you are not going to credit any of the votes for senators. So bibilangin pa muna yung 12 eh. Tapos pagka 12, sige bilang. Pagka 11, bilang din. Pag sobra sa 11, tsaka mo hindi siya bibilangin. And that's for senator alone. How about sa party list? You have 156 party list organization. So titingnan mo kung ilan yung naka-shade doon. Tsaka mo lang pag sinabi, dalawa naka-shade, walang bilang yon kasi one party.
But I think for hybrid that the Senate President Tito Soto, former Senate President Tito Soto was suggesting, was nakasulat yung mga pangalan ng i-votes.
Pero pag nakasulat, ang problem po natin, how do you now count that electronically? So, well, I'm going to show the machine by November in Billionario, and you will find out that the machine is hybridized already. Meaning, the voters, the watchers, and the observers will be able to count manually the ballots. Paano po? When you cast the ballots, the screen, the 14-inch screen will show to you the ballot image. At the end of the voting, counting, transmission, printing of the results, pagtapos na lahat, yung mismong screen will show to the watchers and to the observers all the ballots cast in the entire day. Isa-isa for 20 seconds each. We are going to allow the observers, we are going to allow the watchers take a picture, take a video of all the ballot images. They will count for themselves ilan ang boto ni mayor, ilan ang boto ni governor. Compare that with the posted election returns sa mismong presinto, and then compare with the election returns as printed and the one transmitted. So hybridized na po yung machine.
So that's something new. But will you allow voters to also take pictures? Because I know in the past elections, that's not allowed. You're not supposed to take a picture of your ballot?
At the time of the voting, definitely
Hindi
no
pa rin.
picture taking.
Okay.
But after the voting, casting, the transmission of the result, the consolidation, so alam na lahat yung results, ma'am eh. Papakita namin yung ballot images, hindi naman malalaman sino yung voter doon, sino yung bumoto ng balota na yan. Because wala po siyang indication kung saan. We are going to allow them so that they can count manually the results.
Chairman George, for Congressman Erice, he said that one of the grounds that he pointed out in the petition that was filed in the Supreme Court was the illegality of awarding the contract to Meru Systems because of the requirement that it should have been used in other elections. And his contention was for 2025 elections, the Philippines would be the guinea pig for Meru Systems. Just yes or no, has the Meru Systems that we're using in 2025 been used in any other country?
Yes, ma'am. Because nami-misconstrue niya, namamali siya. The law provides the system had been used before. Namamali siya because ang sinasabi, yung machine. Yung machine hindi pa nagagamit kahit saan. Pero yung system we only have 2 systems available in the entire world. Shading and touchscreen. Diba system yun, ma'am? Yun ang system, yun ang nakalagay sa law sa 9369. He is actually misreading the provision of the law or misinterpreting the provision of the law. We are not, the law does not talk about the machine. The law talks about the system. At itong system namin, may dalawang system siya, Attorney Karen. Yung isa is yung isa ay yung touchscreen at yung isa yung shading. If you are going to use the touchscreen, you are going to turn off the OMR feature. If you are going to use the OMR, which is the shading, you are going to turn off the touchscreen feature. So, not at any given time, hindi pwedeng operated yung dalawang sabay. So, these are the systems being referred to by the law. Hindi naman po yung machine. Ang sinasabi niya, siyempre yung machine, ma'am, talagang bago yan. Bakit? We designed the machine. We were the ones who came up with the terms of reference. 11 times we revised our terms of reference. Parang tayo, nagpapagawa tayo ng bahay, tayong gagawa ng bahay natin. Tayo magdo-drawing. Si architect, si engineer lang ang mag-i-implement yan. Pero nag-drawing kami. Siyempre bagong machines yun. Pero ang gusto kasi nila mangyari, gamitin namin yung mga dati ng machine. That's illegal. That's tailor-fitting. We cannot use a machine which is already existing. Siyempre gusto nating i-enhance man lang ang election natin.
Or
sabi nyo nga,
improve.
oy, bago yan. Walang ganyan dati. Bakit meron na ngayon? Because we are improving. As we go on with the advent of technology, we likewise have to improve.
Yes, and take advantage of what new systems are available.
That's right.
And finally, Chairman George, when can the voters expect to see who are really the final candidates? Will we just see it on the day that we see the ballot, or is there a date we can expect na ito na talaga yung mga candidates that we can choose from?
Attorney Karen, on or before December 13, you, the voters, will be able to see who are the final voters, who are the final candidates, who will be the candidates that will be included in the ballots. But several days from now, we are going to release all the candidates' certificates of candidacy in the COMELEC website so that you will be able to find out sino siya, saan siya nanggaling, bakit bigla na lang sumulpot dito sa atin, ilang taon na ba talaga siya, and siya ba ay Filipino citizen o hindi. First time, the COMELEC will be doing that. Look in our COMELEC website.
Yes, and of course, yung nananawagan din po kayo, Chairman George, no? If you know of any grounds for disqualification, you're encouraging the registered voters to file a disqualification case because sila lang yung makakagawa nun. COMELEC cannot do it motu proprio.
That's right, Attorney Karen. So kindly please exercise your being a citizen of this country. File a petition against anybody.
Thank you again so much, COMELEC Chairman George Garcia.
Thank you very much, Attorney Karen.
Commission on Elections Chairman George Garcia is ready to take on the challenges of next year's elections. While he sees that there are still a lot of work to be done, he believes that the COMELEC can effectively discharge its mandate, especially if the new automated election system provider delivers results beyond what is expected of them. Be timely informed, be insightful of the news. Always stay at the forefront. Join us again tomorrow for meaningful conversations that would help you form an objective personal opinion. This is Attorney Karen Jimeno. Thank you for spending your hour with us.